power sector, primarily coal and gas, as well as the work we do at our state utilities commissions and related work at FERC on a lot of the economic and technical issues that were really at the foundation of the Clean Power Plan, the rulemaking at issue in this case. And we did file extensive, while we weren't involved in the litigation over the Clean Power Plan, leaving that to EPA itself, a lot of like-minded states and some great partner organizations to carry that. We did file very extensive comments as the rules going through the notice and comment phase way back in 2014, like 8 years ago. It's hard to imagine. So for the presentation, I hope it's going to be about 15, 20 minutes, hopefully not too much longer than that. I think if there are, I'm going to rely on Daniel for any questions that come up as I'm going through these very, just a few slides here, but certainly hope that I'll be able to wrap up my bit in that time frame and leave a lot of the rest of the time for discussion and your questions. And certainly some big questions are remaining out there in the wake of this decision. And some of you are, I suppose, maybe lawyers, may be really familiar with this case, and I look forward to having your insights and opinions, especially perhaps if they're different than mine. I always like that. But I think primarily I've pitched this on the assumption that maybe that there are many non-lawyers who maybe not quite familiar with some of the background and details of this opinion. So I hope this is helpful for you, and again gives a nice springboard for discussion on the latter half of the call. I'm going to go through three things. I'm going to give you some background, how we got to this case, go through a few aspects of the majority opinion, and then start talking about some of the implications of the decision. Let me make sure I can advance. There we go. So background. I'm going to try to do three things with this. The background first, just to understand the background, how we got here. But this background is also going to lead into one of my main points that I think is really important about understanding the decision, and which I, in my opinion, find, I'd say, to put it lightly, odd, or one of the two things about the opinion that I think makes it very aggressive and really a ill thought out opinion. In my take, understanding some of the background is important for that. And then I think also when we get to the implications, understanding some of this background is helpful for thinking forward about where we go from here, what it might mean for your work, our work. So the starts, we've got two levels here above what EPA is doing, and then the Supreme Court, the court system below in orange. We'll start with the Massachusetts versus EPA decision, 2007 Supreme Court decision that found that greenhouse gases are in fact pollutants that are covered under the Clean Air Act, and that EPA just can't ignore them. This stemmed from a petition from an environmental group early in the Bush first term, George W. Bush first term, asking EPA to regulate greenhouse gases. It was actually about motor vehicle emissions. Cars and trucks are covered under Title II of the Clean Air Act. Bush EPA said no for a variety of reasons, but primarily that greenhouse gases don't even count as an air pollutant under the Act. We have no jurisdiction here. And that finally made its way up to the Supreme Court, Massachusetts decision. Supreme Court said, no, EPA, Bush EPA, you got it wrong. You do have an obligation to look at this. You can't just ignore requests like this. So of course that was 2007. Bush EPA wasted some time. New administration comes in, Obama EPA much more receptive to saying, okay, Supreme Court, we're going to do something with this. And they come out with the first few tranche of greenhouse gas rules under the Clean Air Act. The foundational one of which is the greenhouse gas endangerment finding, which found that yes, greenhouse gases from motor vehicle emissions are substantially contributing to climate change, which is endangering public health, welfare. That kicked off a few other rulemakings regulating motor vehicle greenhouse gas emissions. Because of the structure of the Clean Air Act, it also triggered some permitting requirements for stationary sources, like power plants, but other sources too. Those rules go along. They're largely survived legal attacks, survived them largely intact. Then another interesting case, so got a pretty good foundation right here for regulating greenhouse gases. That's firmed up in the case called American Electric Power versus Connecticut, where Connecticut, some other states, localities, organizations said, we're getting tired. It's great that we have these rules for new permitting requirements for new power plants, say, but we need to do something about these existing power plants. We're not going to look at the statute. We're going to look at another body of law. It's not found in the statute, but has basically been created through the courts, going all the way back to England, inherited into the American legal system called the common law. There's this federal common law that the courts recognize about nuisance, and it's greenhouse gases are causing climate change. It's impacting us, particularly for the coastline. And we're suing TVA, some other power companies, to do something about it. So the Supreme Court says, get out of here with that case, because there's a statute here called the Clean Air Act, and it allows EPA to do something about this very problem that you're complaining of. In that case, that federal common law is displaced. Something's going to be done about this. EPA is going to do it. And look, here's this perfectly good provision in the Clean Air Act called Section 111D. Look at that. EPA could use that if it wants. And because EPA's got the ability to look into it, no common law, like we can't do anything with your claim. Get out of here. So still the Obama second term, they start doing something about it. They look at 111D and they come out with the Clean Power Plan eventually in 2015. So there's a lot to say about the Clean Power Plan. And again, some of you may be really well familiar with it. In short, to hit the salient points, I think, for this discussion, they lean on the 2009 endangerment finding to say, okay, we have to do something about greenhouse gases from power plants. They're a major contributor to this problem. What are we going to do about it? So under 111D, they look and decide what is called the best system of emissions reduction to reduce this problematic pollutant, greenhouse gases. So like, what's the best? There are a lot of aspects to it, but basically, what's the best way to go about this? And EPA looks at the system and looks at the power plant systems. Like, well, all these power plants are connected, right? They're part of a system. And we see a lot of trends where there is a less generation coming from coal, just getting old. A lot of the fleet's getting old. Might be some switching to gas, fewer greenhouse gas emissions coming out of the smokestack, a lot solar, like look at the price trends on solar, look at all these other things that can be done on the system that would reduce the amount you need to run from these fossil fuel fired power plants that are creating greenhouse gas emissions. We're looking at that reality, and we're going to take that as the basis for deciding what actually has to be achieved in terms of emission reductions. So that's the basis. That you might have seen generation shifting phrase, but that is, and this is an important distinction I think that sometimes gets lost. That's the basis that's the approach that EPA uses to come up with what the requirements are. And those requirements are state specific. They took a few different forms, but basically the one that most people focus on and we talk about is like, what are the greenhouse gas, what are the CO2 tonnage that this can come out of the power sector in this state in 2030? That's how EPA said it. We looked at this power system, we looked at the trends in the sector, and we see a lot of coal going away. And we think, given these trends, emissions can come down this much in this state. Overall, the national average was a reduction of 32% by 2030 over 2005 levels. Some states would have a larger percentage reduction, some less. But again, importantly, the states, once EPA sets that goal line for the state, they certainly have EPA as a basis for it. The state does not need to use that approach for actually achieving the reductions. They could come up with something totally different, some different way of achieving those emission reductions. They do need to submit that plan to the EPA for approval, but it does not, how the state goes about achieving those emission reductions does not need to look like what EPA used to arrive at that number. So, Clean Power Plan 2015, we're off and running. And then the Supreme Court steps in a few months later before anything gets going about implementing the Clean Power Plan, before the states are even really seriously thinking about putting together their plans. And very unusual move in early 2016, EPA said, or the Supreme Court says, look, we don't like the look of this. It's a big deal. We're not really sure this is going to fly legally. We're going to stay it. Clean Power Plan never goes forward from there. Basically just stops. 2016 election comes, again, a change in administration, change definitely in perspective, the Trump EPA. Trump EPA comes in and says, we don't think we have authority to do this Clean Power Plan approach. We're going to repeal it. And we're going to come out with something called the Affordable Clean Energy Rule, which instead of looking at the system as a whole, said, no, we can't do that. We're going to look at just what can be done at a specific power plant. What can be done there to reduce emissions at the power plant? So they use things like efficiency of the actual operation of the plant, what sort of emission reductions can be done there. So you might imagine that's a lot less than what can be done if you're taking the system-wide approach. If you're looking, in another phrase you might have seen, beyond the fence line. That goes forward, that gets challenged in a day, I think, before we had another change in administration with Biden EPA coming in January of 2021. The DC Circuit Court of Appeals struck down the Clean Power Plan repeal and also the ACE rule, the Affordable Clean Energy Rule. Biden EPA comes in very soon after and says, okay, court, can you please just stop? Let's just stay the impact of your decision. And because we want to take our crack at this, we're going to do something different. We're going to take our stab at it. Not going to be the ACE rule. We don't know what it's going to be, but we want our time to do it.
Oh, this is Patty.
The losers in that, the West Virginia, other states, some industry, nevertheless, petitions the Supreme Court to hear, review the DC Circuit opinion, striking down the Clean Power Plan, repeal the ACE rule, and Supreme Court takes it. So that's how we got to where we are. So the first, the two things that I think are really problematic about this opinion, again, the same slide, is the jurisdiction, the power, why the Supreme Court would be taking this case at all, right? Because the Clean Power Plan, it's all about the Clean Power Plan. Clean Power Plan never went into effect. And the administration, the current administration says, we don't know what we're going to do. We're not wedded to the Clean Power Plan. We need to go back. We need to take a fresh look at this. There is no Clean Power Plan. Nevertheless, the court opines on the Clean Power Plan. That's all the opinion is about. It was just really unusual. And for whether you like to put judges and justices in a liberal bucket or conservative bucket or activist or something like that, that's not something courts are really hesitant to do. And there's a very principled path for the Supreme Court to have said, look, it's premature for us to weigh in here because we don't know what the Biden EPA is going to be doing. Clean Power Plan is not coming back. Why would we take this case? Well, but they had some itch. There are obviously enough justices there that had some itch. They needed a scratch, so they took it. And that's really, that's a very aggressive move. Very aggressive, very unusual. But obviously, they didn't think so. So the basis, what the court relies on for the doctrine of saying that the Clean Power Plan approach was impermissible, is what had before now really been a fringe legal doctrine called the major questions doctrine. Usually when courts are reviewing something that an agency, executive agency like the EPA does, it's like, well, where are they finding the authority in the statute? What's the wording there? If the wording is clear, we're really going to defer to the agency on how they are seeing that, how they're exercising the authority that Congress has given them under the statute. Major questions doctrine starts to really undercut this in a troubling and really unpredictable way going forward, I think, which is, well, yeah, unless it's a big deal, unless what the agency is doing is going to have a really big impact. It's going to have a transformative impact. It's going to have up in the social, political, economic landscape of the country. Like, we're going to take a closer look. We're not going to defer to the agency. And specifically in this case, the things that the court, some of the chief things that the court looked at is they said, well, they found the wording, what is meant by best system of emissions reduction, is vague. They said Section 111D was a literal used backwater of the statute, and that EPA was using it to claim a broad new power that would have a broad transformative impact, again, on outside their usual purview. And in here, it was going to be restructuring the American energy market. That's what EPA was going to be doing in the Clean Power Plan, in the majority opinion take. So there are a lot of things to quibble with about, like, that it's a little used backwater, that it's a broad new power, that are really are weak. And there are definitely some very, in my opinion, very strong arguments about why that's a really inaccurate take. But I thought the thing that really stood out to me, and this is the second of the two things about the opinion that I think are very odd and very aggressive, is this is a really, if they want to really trot out and put the major questions doctrine in the center of jurisprudence, for federal courts now in America, this is a really, really strange, really poor set of circumstances in which to do that and try to hold up the major questions doctrine and this new type of scrutiny on what federal agencies can do. And that's because the Clean Power Plan, there's an interesting experiment here. Because the Clean Power Plan never went into effect, right? We can see what has happened in the power sector, right? And remember, what the Clean Power Plan was projected to do, what it was going to require, when all the states had hit their targets in 2030, so overall going to be a 32% reduction from 2005 levels. But what has happened in the absence of the Clean Power Plan is that nationally, that 32% reduction was achieved in 2019 without the Clean Power Plan. So it's really, there's something that doesn't compute there, right? It's like, how could the Clean Power Plan have a revolutionary impact if the power sector achieved these things all on its own for the exact same things that trends that EPA used and looked at to set the targets in the Clean Power Plan? If anything, EPA shows that EPA was far too conservative. So here's just an example just for the 6 states that SELC covers. the 2005 levels to 2020 levels, that's actually for our states, that's a 50% drop. And there are a lot of other states, some are higher, some are lower. All of our states, a lot of them very fossil fuel dependent, met what the targets that they would have had in the Clean Power Plan, like 2019, 2020. So it's a really strange way to say, well, this rule was going to have this upend the energy market, and the energy market did it all by itself. Now, there are some limitations here, and this is a key, I think, part of the opinion near the end of the majority opinion, saying, look, we're looking at whether what EPA did in the Clean Power Plan and their interpretation of best system of emission reduction passes muster. We said no, but that's all we're doing here. So that leaves open two things. So that limits it in two respects. One is that what the Biden EPA can do now, they get back balls in the Biden EPA's court now on what to do with 111D. It's for sure they can't take the system-wide approach, right? They can't take into account this reality of how this sector operates when trying to look at what could be done in reducing greenhouse gas emissions. Can't do that. But what could they do? They're going to have to look at things that could be done at the source, but they still may be able to use this approach, which was an element of the Clean Power Plan, where they set this cap, and then there can be some trading and flexibility. So it's not EPA. It's not clear from this opinion that EPA has got to do something like was done in the ACE rule, which is plant-specific limitations with no flexibilities. Like there is something still available to EPA. The basis of how they come up with, say, a state target is sharply limited now. They can't look outside the fence line. But they can base it on what could be done at the source and still set that target, right, for a state. And then the state, again, can use a different way of complying, which could be generation shifting, I think. So there's still some wiggle room in there. No doubt EPA is going to be sharply constrained in their methodology and then in the robustness of the targets. But there's still some flexibility in there. And then the other limitation of this opinion is the application of the major questions doctrine in future cases. We're going to see that a lot more. There's no doubt about that, and it's going to be successful in some respects of constraining what agencies do and having the courts look over their shoulders. But there is reason to believe, like, well, there has to be vague wording. It has to be a little use backwater of the statute. It has to have this broad new power of transformative impact. So there are definitely some things to lean on if you're going forward, and no matter what area you're in, about, this is not open season on like applying the major questions doctrine all over the place. There are going to be attempts to do that, but there are good arguments based on this opinion to limit that to some specific set of circumstances. So implications, and I've started talking about this, and talking about the limitations about, well, what can Biden EPA do now for 111D? They're going to have to base it on things that can be done at a specific power plant. What can be done inside the fence line? But then once they use that as a basis and they say, okay, Virginia, where I am, we looked at these technologies and we look across the power fleet and it would result in these emission reductions. Here's your target. Give us a plan on how you want to meet it. Could be these at the source inside the fence line approaches, could be something else. For EPA, and really for other agencies, this major questions doctrine, has got to be something they factor into account when they go about regulating, outside this context, outside the Clean Air Act. They need to look at some of those things that the court relied on and see if they're all met, and they're going to have to be more careful. It's definitely going to have impacts for other attempts to tackle greenhouse gas emissions and address climate change. The SEC has a climate disclosure rule. FERC is looking at this, and certainly one of the commissioners at FERC, used to be a commissioner here in Virginia, is already talking about how, yeah, I told you, FERC, my fellow commissioners, major questions doctrine. It's Mark Christie. And it's going to be hard to get away from that for climate change, just because the problem is so big, right? To really do something about climate change, it's going to be big, and that means it's major questions doctrine. For those of us who are going to be trying to move the federal government to do things, major questions doctrine is going to be right there in the mix, and this is going to be part of our legal life as we go forward. So I don't know how. Hopefully it wasn't too much over 20 minutes. We've still got some time left. But I'd open it up for discussion, questions, and any takes that anybody would like to put on the table.
I had one. Is it, you were talking about how like the CPP gets repealed and then we have the ACE rule, and then it just seems like it's bouncing back and forth. Is that something that's normal when you have administration changes, to have those kinds of sort of bouncing?
Yeah, this is, it is what's unusual here, at least in my experience here. So I've been doing this for about 20 years, involved in the Clean Air Act for like 20 years. Right when the George W. Bush was coming into office, and you definitely had to switch from Clinton, and Clinton, there were major Clean Air Act amendments in 1990, so a lot of the Clinton 2 terms did a lot of implementing those Clean Air Act amendments, and there definitely was a big switch, when they had the Bush EPA come in, and specifically something like, you've got an existing court challenge like that's ongoing for the Clean Air Act. Anything that's of national impact always goes to the DC Circuit. So it's usually talking about the DC Circuit Court of Appeals. And so you can pretty much bank on it. You have a change in administration coming in, they're going to say, okay, pause this case, court. We're looking anew at this. Maybe the people challenging this actually have a point, and we want our time to take a look at this. What is a little unusual here is that you had that going from Obama to Trump, and then Trump back to obviously Obama's VP, very like-minded. So you had this, what you have is not just the switch, one-time switch, you have it switching back, which just further complicates it, because the legal, it's in the nature of the legal apparatus, like it doesn't really keep up. It moves, it plods along, right? The other thing probably that was going on here is Trump EPA, they didn't have their act together in some just pretty basic ways of getting things done, right? Remember Scott Pruitt, that guy? There was all, it was one of these like up-teen 50, Trump scandals, Trump administration scandals, and he got fouled up, and then Wheeler comes in, and it's so in a way, it would have been a little bit cleaner somehow if the Trump EPA had sort of moved along. So a little bit more complicated than usual, but this is what you do get. This is just part of it's inescapable. This political winds change, but the legal mechanisms don't quite keep up. It happens both ways, going, no matter what direction you're going.
It was another thing that I was wondering, we just had the Inflation Reduction Act,
Mhm. Oh, yeah. Thank you.
and with that and its environmental, how do you see possibly the EPA's role being in that, and how that can affect, um, maybe with
Mm.
on the local levels and our city levels and stuff, um, their environmental pushes?
So there, so I meant to talk about that a little bit. I'm glad you raised it. There are two aspects to that. One is it um, it definitely came along at a good time, right after this opinion, and my personal view on this is right. It's going to take action at all levels. Like it's never going to just be at the local level. It's never just going to be the state level. It's never just going to be the federal. Eventually, to really get things going in the right way at the speed we need them to be going on climate change, we're going to need action at all levels. And so what's great about the Inflation Reduction Act is that just as what we had hoped for, this key federal tool that we've been hoping for about a decade, um, boy, it's not going to be what we had hoped. I mean, it was never really, it was never that strong, but at least we're going to have it there on the books and we could ratchet it down, make it more useful, right? That's not going to be there. So what it means is like what happens at the local level, it's you got to sort of step up the game. Like it's even more important now. And the inflation, I know there's a lot in the Inflation Reduction Act. But certainly there's a lot in there that seems like it's going to be a big boost to things being done at the local and state level, right? It uses the carrots, not the sticks. And eventually we're going to need some sticks, no doubt about that. But, let's put those carrots to use, get these reductions. The actual impact on the EPA, particularly for what they do now with 111D, it's not going to have that much bearing inside the strict scope of, okay, EPA saying, well, what are we doing now about 111D? Inflation Reduction Act, I don't see a specific of relevance, like a direct relevance there. However, I will say, and some of you might have seen this just this week. There was New York Times story, and then a little bit of pushback. There's a little bit of debate about this. That there actually is a provision in the buried and maybe a little used backwater of the Inflation Reduction Act that amends the Clean Air Act to define greenhouse gases to be specifically like carbon dioxide, methane, and so on. And so there's a little bit of debate, some really highly respected voices, in fact, key lawyers that were involved for the environmental groups that were involved in supporting EPA, were involved in the petition, in the litigation all throughout Obama, Trump, and now Biden years, really think it's a big deal. Others are saying, well, just, defining greenhouse gases to be these particular, carbon dioxide, other chemicals is not that big a deal. It certainly doesn't undo the damage of the West Virginia opinion. I do see it as it's definitely helpful to have it in there. It's like, okay, Congress has spoken to this, and this is certainly one thing about the federal court system, particularly the current makeup of the Supreme Court. If for things that obviously go beyond the environmental realm, there's this feeling like all bets are off with this court. You don't know what they're going to do. So having something in there slipped into the Inflation Reduction Act, say, hey, EPA can regulate greenhouse gases. Here are the greenhouse gases. It doesn't hurt to have that backstop in there. So that's another particular element of the impact of the Inflation Reduction Act and EPA, and particularly for what they're going to do with Section 111D.
Hey Frank, I'm Robin. I don't know if anyone else knows me, but I do communications for Greenlink. I have written about energy and environmental issues for a while. I think the information you've given everyone so far is super interesting. I think it brings us up to date kind of where we are, but I just wanted to make sure, reach out to everyone who's on this call and see if you guys have any questions, because there's a lot of information going on. I know there are people in community-based organizations, people work at the city level, people who are looking at the commission level. Like, I just want to make sure if anyone has any questions or thoughts or responses so far to the information.
Well, I will let me, well, folks are maybe thinking of questions. I will offer another thought, particularly if you're part of a local government, particularly if you're one of these localities that's got a sustainability or climate goal. You know, like I said, eventually Biden EPA is going to come out with something. You know, hopefully, eventually, it'll survive and actually go into the implementation phase that the Clean Power Plan never got to. And yeah, so I just want to reiterate one thing I said, which is, right, then it's a state game, right? EPA is going to give them, you know, here's the target, you give us a plan on how to meet it. It certainly seems relevant to say, well, for a state, you know, this is not all about EPA, it's also about, you know, states and how they implement it. And if you can get before your, you know, state government, state environmental agency that's in charge of implementing the Clean Air Act, where you are, and some localities have that authority too. What is happening at the local level? Again, whether it's through, you know, benefits from the Inflation Reduction Act or just things that are already in the works and happening, and let's say, you know, you're trying to get out of your power contract with a big utility that uses a lot of fossil, and because you're able to do that because you're being more aggressive on energy efficiency improvements in the city, or better distributed solar policy, or community solar. Like, those things are relevant for a state. Like, EPA may not be able to take those into account when they set the target, right? When a state decides, okay, how are we going to implement it? Those sorts of things are relevant. So hopefully we'll get there. You know, we'll come back around to that implementation phase. But when you do, you know, there's a role there to help the state come up with a common sense way to meet that target.
Frank, I've got a question for you that's going to start at the federal and then go down, and it's kind of big.
Okay.
But we've now had, you know, all three branches at the federal side make some sort of significant climate action, right? We've had, especially, and most of this group is pretty heavily focused on equity work. So on the equity side, you had the J40 executive orders that came down. Congress finally did something for the first time in forever. I'm basically close to literally on that in that case on climate action. And we've got the Supreme Court ruling. And these are kind of all in different directions. How they're going to be mutually reinforcing or canceling out is kind of, at least to me, a bit up in the air. And how that's, but at the end of the day, the way that I normally look at this stuff is that all of this stuff is going to happen in a place. Like, this is ultimately all going to happen in some sort of local community. And so the question I wanted to put forward here was, like, how do you think that community groups should be working with public service commissions or other regulators at the state level to use these legal levers of political power and the funding that might be coming down, but also that has to now color within the specific lines that are being drawn on the judicial side there to better achieve these environmental, climate justice, and equity outcomes that they're really heavily focused on.
That is a big question, and in an important one, because right, for a group like SELC, and other groups like us, that particularly ones who appear before the public service commissions or FERC, like we in the traditional environmental partners and have become more intentional and better, not done, but better at folding in the equity elements that are all wrapped up in this transformation that we need to see of the power sector. And we represent groups that are really expressly, focused on those energy equity issues. But we don't have, I don't know if I want to say cachet, but we don't have quite the same legitimacy, I think, maybe if that's the right word, of a local, like particularly a local government or a local group that's working through a local government and very active in that space. Like, to be able to bring that perspective to a commission is a really helpful real world like check. It's like, I think of the prototypical commissioner that we might appear before. They sort of like, well, these groups, SELC, sure, they're smart. They got good expert from Greenlink. It's good as far as it goes. But, I think there is definitely something. We've made some serious inroads, like how seriously we're taken. But I think maybe we're sometimes seen as not quite clear how in touch we are with the reality. And I think groups who are really that are set up to be in the communities, or you're a representative of actual local government community, to come to the commission, to say what's going on, to say what you're planning on doing, especially given the Inflation Reduction Act, all those carrots. If you go out and say, commissioners, we just grabbed this big bushel of carrots, from the Inflation Reduction Act, and this is what we're doing. That definitely helps, because too often it can become this a dynamic for the commissioners, like these environmental groups, maybe consumer groups, pushing the utilities to change. Utilities are using their usual argument about it's just too much, like there's reliability here, the economics here, and they sort of put their finger on the scale all sorts of different ways. But then to have that different type of voice come in, helps legitimize the types of arguments that we tend to make about, hey, commission, you should compel the utility to do more here. There's really more that can be done. And to have somebody coming in from a different perspective, but is sort of pointing in the same direction about things that are actually happening, like that's great. And right, and there are different ways to do it. You don't have to intervene necessarily in a proceeding. There are opportunities to just file comments, or just to show up on the hearing day and talk for a few minutes. And I would say at FERC, it was one big thing at FERC. Again, some of you may know this Office of Public Participation has been set up particularly to get community groups help their voices be heard at FERC, as FERC works through these issues for the things that are under their authority. So that's something in particular that's been encouraging at this since the Biden EPA and the current makeup of the commission, Mark Christie notwithstanding. He's a fine person, but a little disagreement.
We had a question come in from the chat from Albert Lee. Down the road, could this ruling affect state exceptions to EPA regulations, such as California's cleaner car standards?
That's a good question. I have not thought about that. I mean, I saw the announcement from California about requiring all vehicles sold by 2035 to be electric. I want to say, yeah, expect it. Probably be no end of ways in which the proponents of the major questions doctrine are going to try to use it. But if it's something that a state is doing, it really ought to take it out of that. It really ought to be able to like put major questions doctrine aside. If there's something about EPA though authorizing the state to do this, I think it would put it more in the ballpark, but it's hard to see how you could say what EPA is doing, even if it's for California, could have like such a big transformative broad impact, right? It's not, this is like either it definitely, it's pretty explicitly like when you're talking about invoking the major questions doctrine, it's got to be something that's having a big broad impact, not just one state. But if you're talking about California, given the impact that California can have because it's such a big part of the economy, if I was a major questions doctrine proponent, I'd be thinking about trying to get it in there somehow. But I got to think it would not be. I would hope it would not be successful.
All right. Well, thank you so much, Frank. That was excellent information. Thank you for joining us. I wanted to say real quick before we wrap up, we are going to be sending out a survey about GEM, community of practices, office hours, a lot of different things. If y'all would be so kind as to fill that out so that we can always better serve you. And then also I wanted to drop in my email since I'm sure I'm new and some of you may not have it. If you have any questions, any GEM, anything, feel free to send me an email and I'll get you an answer, get you set up, or find somebody that can. Thank you all for coming, and we will hopefully see you next month.
Thanks, everybody. Thanks, Daniel.